Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Everybody, good morning and welcome to class number 9 of our 2025 Virtual HOA and Condo Academy. Today is Tuesday, September 16th, and welcoming all of you as you're joining our presentation today. I'm going to give just a few seconds for attendees to enter the Zoom and to get settled here this morning, and also to get this broadcast on Facebook Live. Welcome to class number 9 of our 2025 Virtual HOA Condo Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. As you may know, if you've attended prior classes with our firm, I've represented HOAs and condominiums in the state of Arizona for over 28 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. Our session today is going to provide an easy-to-understand overview of the new legislation affecting HOAs and condominium boards. We're also going to address current insurance challenges facing HOAs and condominiums and offer practical tips on preventing crime and limiting liability for your associations. As always, we will have question and answer at the end of the presentation. I will conclude the main presentation hopefully right around 12 o'clock, and then we'll move right into questions at that time. Due to the large volume of questions we receive, please note that there is one question per attendee. If you're joining us on Zoom, please be sure to submit your question in the Q&A box. If you're joining us on Facebook Live, please type your question in the comments section. Okay, we're going to start out today with a poll. Which city do you reside in? Is our first question for today. I always like to know which cities are represented when we're teaching these classes for the different neighborhood services. So I would really appreciate it if all of you would respond to the first question. And then the second question is also let us know what your role is so that we can tailor the class today to best fit who the audience is here today. And while we're waiting for those results to come in, let's go ahead and get a head start on our presentation for today. Okay, so today we're going to be talking about the new legislation first. The Arizona legislature began their 2025 session in January of 2025, and they adjourned on June 27th, 2025. So just over 6 months the legislature was in session in 2025. It was an unusual year in that there were a lot of bills that were introduced pertaining to HOAs and condominiums, but ultimately only 4 bills that directly impact HOAs and or condominiums were passed into law this year. These 4 new laws, which we're going to talk about here in a minute, will become effective on Friday, September 26th, so in a little bit over a week. Additionally, there were 3 other bills that were signed into law that may be of interest to our clients. We're going to briefly talk about those today as well. Those of interest bills will also become effective September 26th unless otherwise indicated. Okay, so let's get right into it. The 4 bills that you need to be aware of that passed in this year's 2025 Arizona legislature. And again, these bills will go into effect on Friday, September 26th. Senate Bill 1039 talks about recording of open board meetings. This bill applies to both planned communities and to condominiums. And it just requires that if a board is going to record a meeting, and it's becoming very commonplace because a lot of boards are having their meetings now on Zoom or hybrid with Zoom. So if the board is recording their meeting in your planned community or condominium, and that meeting is open to the members, so this does not apply to executive sessions, the board shall keep a copy of the recording of that meeting for at least 6 months and make the unedited recording available to any member on request. So just kind of a change in protocol. If you are recording your open board meetings, you must, as a board, you must keep that recording for 6 months. And if an owner requests to see it, they're entitled to see an unedited version of that recording. Okay, the second law talks about political signs. It's Senate Bill 1378. This applies to both planned communities and condominiums. And this bill changes the definition of political signs to include a sign or a flag. I think this is just kind of a sign of the times bill. As you know, in our most recent past two presidential elections in our country, we saw political signs in the form of a flag. And I think our legislature is just now including that directly, or being more specific about the fact that a flag can also be a political sign. So next election cycle, which will probably be coming up here in November, it's kind of uncustomary, in my opinion, to see political flags for elections that aren't national elections, but the next presidential election will probably see this come up again. And if an owner wants to fly a flag that is a political sign, that will be allowed as long as the provisions pertaining to political signs are abided by. And those different provisions include like how soon you can put the flag up and when you have to take it down after the election. Okay, the next bill, this is kind of a little bit more of a controversial bill. This is Senate Bill 1494. This only applies to planned communities, so this does not apply to condominiums. And this is going to change a little bit the foreclosure process that our clients or associations in general, planned communities in general, will be subject to this new law. And it's going to make it a little bit more difficult to foreclose if you're an association and you're foreclosing on an owner for not paying their assessments. So the prior law allowed us to foreclose. There was like some benchmarks that needed to be met to foreclose previously. Those benchmarks were that you had to have 12 months, of the delinquency in assessments only for 12 months. And then the dollar amount was for $1,200 before we could foreclose in assessments only. And so they've made it a little bit more difficult in that now we cannot foreclose until the assessment period that's unpaid is 18 months, or they've reached $10,000 that's owed. So probably for most of our clients, 18 months is going to be the threshold because $10,000 is going to be quite high for planned communities. And so just something to think about if you're on the fence about foreclosing on somebody between now and the date that the new legislation is going to go into effect, Friday, September 26th, you may want to file your foreclosures before Friday, September 26th, so that you don't have to comply with the increased difficulty to foreclose based upon this new law. So again, going to be a little more difficult for planned communities to foreclose. We'll have to wait either 18 months of unpaid assessments or $10,000 that's owed. And the next bill is, and again, that does not apply to condominium. The next bill is House Bill 2322. This is going to be kind of a limited, but this does indicate that it talks about condominium. It applies only to condominiums, House Bill 2322. And it addresses assessments on commercial versus residential structures in a condominium. Also included in this bill are some definitions of commercial structure, common expenses, and residential structures. So just gives us some guidance if you are a commercial condominium versus a residential condominium. Okay, some other bills. Those are the four big ones, and probably the ones that you're going to see the most on that are going to be if you're a planned community, it's going to be a little more difficult to foreclose, as we talked about. If you're video or audio recording your open board meetings in your planned community in a condominium, you have to keep that recording for at least 6 months and make an unedited version available for your owners if they request it. And then, of course, the flags, political flags, are going to be treated like political signs going forward. So considering how many bills were introduced this year, the fact that we only have those four is actually probably pretty good. The one that I wish did not get passed this year is the one with the foreclosure, additional restrictions on foreclosure, because I do think it's going to give homeowners who don't want to pay their assessments a longer period of time that we have to wait, and it may make it more difficult to collect on those debts. Okay, what are some other bills that just FYI we want you to know about indirectly related to associations? Senate Bill 1022, the small claims court jurisdictional limit was raised from $3,500 to $5,000. So if an individual, some HOAs and condominiums are filing in small claims court, maybe their management company is helping them with that. Now the jurisdiction is up to $5,000. So that means you can sue for up to that much owed once the effective date of this new legislation goes into effect. Senate Bill 1070 talks about tax deed land sales and procedures. This would allow a county board of supervisors to sell real property in the county held by the state by tax deed to the owner of a contiguous real property that is used for commercial, agricultural, or residential purposes. It also authorizes the County Board of Supervisors to sell similarly situated real property to a homeowners association if the property is part of a common area maintained by the homeowners association. So if the taxes aren't paid, it might be kind of like a recovery effort for the HOA to get their common areas back if they're sold. House Bill 2928 talks about accessory dwelling units and requirements. And it addresses the regulation of accessory dwelling units by municipalities and condominiums. If you're having issues with ADUs, this law is something that you probably want to take a look at. Most of our clients don't have accessory dwelling units, so I'm not going to go too deep on it, but that's House Bill 29. Okay, let's hop right into our main presentation for today. Oops, can't forget the poll. So we have our poll results back, and it looks like we have really good representation from all of the different neighborhood services departments that we are teaching these classes for today. So we have 2% from Avondale, 10% from Chandler, 2% from Glendale, 4% from Goodyear, 40% from Mesa, 2% from Peoria, 10% from Phoenix, 16% from Scottsdale, 10% from Surprise, 4% from Tempe, which is just a great turnout. Every single city that we're teaching the classes for here today have representation, which is amazing. It looks like at the time of the poll, we had about 94 people in the class. I know that that doesn't include our Facebook Live viewers. And I know a bunch of you have joined while we were talking about the new legislation too. Let us know your current role. So we have 59% of you are board members, 6% are managers, 30% are interested homeowners, and 6% are other. So great representation today. Again, as always, we're seeing a lot of board members who are joining these classes. It's basically 2-to-1 board members versus homeowners, but we're really happy that the homeowners are here too, listening, learning how they can make their communities better and making sure holding their boards accountable to make sure that they are doing what they're supposed to be doing by following the law. Okay, let's talk a little bit about insurance. Insurance has been a really hot topic for boards the past few years. I think we can all agree that probably the hottest part of that topic is that premiums are going up and associations are struggling to find insurance. They're struggling to meet the expense to pay premium increases. And we're receiving calls at least once a week from clients saying, hey, we just got our renewal notice and our premium has doubled, or in some cases gone up even more than that, or even worse, the insurance company is just refusing to even write a policy for that particular association. Rising insurance costs are definitely a hot topic right now in our industry. New data from CAI's Foundation for Community Association Research is underscoring what many homeowners boards and community managers are experiencing. According to the Foundation Insurance Coverage Trends SNAP survey, 91% of community associations experienced an increase in insurance premiums. 17% saw increases exceeding 100%. 3% shifted to surplus line carriers due to lack of traditional insurance carriers. 20% reported losing access to one or more insurance carriers. And many reported rising deductibles to kind of counterbalance the increase in the premiums, decreasing their limits, and limited market availability in disaster-prone states. California, Florida, Texas, North Carolina, Arizona. A lot of these states are experiencing these issues. While these trends vary by region and the different types of properties that are out there in the United States, it's clearly a message is being sent that there are now new financial pressures being placed on boards and homeowners when combined with the association's responsibility to maintain the infrastructure, fund reserves, and meet lending compliance requirements. And so this is a problem that many associations are facing. Okay, what would be some other things that we're seeing? Okay, let's talk a little bit about, what are some pivots that associations have if you're running into a situation where the premium increase from your current carrier is too high? Well, you should definitely be shopping the market for your insurance. Now, what you need to know is that 60 days before your insurance policy is renewed, you will receive a notice of renewal or non-renewal. And if you're receiving a notice of non-renewal, you definitely need your manager, should be your management company. If you're managed by a management company, should be notifying you immediately that this has occurred, because you need to be very agile and pivot right away if your current insurance is not being renewed. You may want to reach out to your legal counsel. You definitely want to talk to your insurance agent and see what their recommendations are to help you through that difficult time. What about if your premium goes up significantly? Again, shop the market. You may want to think about playing with your deductibles, have a higher deductible so you're self-insured as an association up to a certain dollar amount. Make sure that you are not changing the insurance coverage that's required by your CC&Rs, or if you're a condominium, that may be required under the Condominium Act. Again, reach out to your trusted advisors, your insurance agent, and your legal counsel to help you navigate that. And you got to do it right away as soon as you get that premium increase notice, which is typically about 30 days before it's due. Some associations are doing amendments to their CC&Rs to change insurance responsibilities from the association to the owners. That's very difficult to do. And in light of recent case law, that may be impossible. You may need 100% approval of your membership to do that. But it's something that as a board, it's a consideration, and you should talk with your legal counsel about that to see if that's something that might be able to help your association. Not having insurance for your common areas is something that is not an option from my perspective as legal counsel for associations. And so most association CC&Rs have a requirement to carry insurance. And so just saying, well, we just won't carry insurance is not a good business decision and could result in really severe liability for your association. One other trend that I've seen recently in condominiums is that insurance companies are becoming more involved if there are problems in terms of maintenance problems or infrastructure problems in your community. We've seen several associations that have the insurance company mandating that the associations, and this would be like in a condominium, mandating that the associations take certain actions in order to have continued insurance coverage. So that's kind of another new trend that we're seeing. So for example, sometimes the insurance company will send out a representative to your property, and they're going to do an evaluation of the current condition of your property prior to a renewal of your insurance policy. And they may come up with a laundry list of things that you need to repair or bring up to code before they will renew the insurance policy. So that's a trend that we're starting to see more and more with associations. We have a great cheat sheet, and there's also a great article that was written by CAI, Community Associations Institute, national think tank helping associations, condominium plan communities, board members, and homeowners navigate issues that face community associations in the United States. So the CAI article is on navigating insurance pressures in today's condo market. We're going to be sharing that with you here right now. And then we also have a great cheat sheet on insurance, protecting the association and the board, that our firm has put out. We can find that on our website at mulcahy.com, or we also will be sharing it with you on Zoom and Facebook Live today during this presentation. Okay, so we talked about the big hot problems, the trends right now that are facing associations on insurance, premiums going up and not being able to get insurance, et cetera. Let's now turn and do a little bit of a overview of what exactly insurances an association may be required to carry, and any special information about insurance that will be helpful to your board. Okay, quick little insurance overview. Obviously, protecting the community association and the board requires a close look at insurance coverage for your association to prevent coverage gaps that become obvious after there's a problem, right? Just some information about what types of insurance there are out there for associations. Let's just start right from the top. So I would not serve on a board unless the association carries directors and officers coverage. It's often referred to in slang as a D&O, or directors and officers, or E&O, errors and omissions insurance. This typically covers the board of directors. It may also extend to committee members. Common claims against associations include the board's failure to follow the governing documents, or maybe they're not maintaining something, or maybe the architectural committee makes a decision that an owner is aggrieved about. And so maybe somebody thinks that the board has breached their fiduciary duties to the association or breached the contract, the CC&Rs. Occasionally, we'll see Fair Housing Act discrimination cases filed against an association. And so basically what the D&O or E&O coverage does is it's a policy that the association carries. And basically what happens is it includes indemnity coverage for the cost of defending actions that are filed against the association and individual board members. And oftentimes it's going to, it depends on how the policy is written, but it's going to provide insurance defense in terms of a legal attorney will be assigned to by the insurance company to defend the association or the individual board members if the individual board members are named. And again, the most typical lawsuits on this would be that you have a homeowner that's aggrieved about something and they are filing a lawsuit against the association and maybe the individual board members, and they're claiming that the board didn't do something that they should have done or that they did something and they did it improperly. And if a lawsuit like that is filed, having this insurance coverage, the D&O or the E&O coverage will provide the association and the board with legal defense in the form of an attorney that's assigned by the association's insurance company. So, no one wants to serve on a board if they think they're going to have personal liability for being a volunteer board member. So this is another level of insulation in addition to the indemnification provisions under state law and the indemnification provisions that are typically under an association's bylaws to indemnify an association's board member in the event that they're sued for taking action as a board member. So a lot of times I'm asked, how much does a D&O policy cost? Well, it depends on, what type of coverage you're getting. Like sometimes associations have $1 million, sometimes they have $5 million, sometimes they have $10 million, depending on how large your association and what issues are facing your association. We've seen for the $1 million policy, premiums are typically in the range of $900 to $1,500 a year. Okay, let's switch gears and talk a little bit about property insurance. Property damage claims are more common, frankly, than D&O claims. I receive an email every morning from a source that, we pay to get these emails from. And basically what it does is it tells us the name of every lawsuit that was filed in Arizona in the previous day. And so I have a pretty good pulse on what the issues are that are facing associations right now, legal issues, because every day we pull out the cases specifically that apply to associations, and we kind of take a quick peek at, okay, what are the most common lawsuits that we see? And so we typically do see a lot of property insurance type issues where an owner trips and falls on the common area, or there may be damage to an owner's property. And so in our experience, property damage claims are actually more common than D&O claims based upon the lawsuits that we're seeing filed in Superior Court in Arizona. What you definitely want to be careful about on the property insurance is you want to make sure that you have enough insurance based upon what your governing documents state. And so talking with your insurance agent and your legal counsel to make sure that you have adequate insurance based upon what your documents or what state law may require is very important. When you're new to the board, something that you want to be thinking about is when the renewal comes up, that's a great time to invite the insurance agent to your board meeting and ask them to review the provision in your documents and to also then review what your current existing insurance is and make any recommendations with regard to the property insurance to make sure that there are no gaps in coverage. Or also make sure that if there are specific things, like if you're required to have guaranteed replacement costs, are the numbers set adequately based upon the current value of your association? And so that could result in you may need to have your property appraised, or maybe the insurance company will provide that information to you. And so property damage claims, like I said, are very common, and you need to have property insurance in addition to the insurance that's going to cover the board, maybe any committee members, the D&O insurance. The next type of insurance that's important for associations to have is fidelity insurance. Fidelity insurance covers theft and fraud of association funds, basically. And fidelity insurance should be issued in the association's name with the property manager obligated under the association's policy. By structuring it in this manner, the insurance will cover a theft by the management company principals as well as their property managers, in addition to board members. The management company usually has its own fidelity insurance, but that's going to typically cover the property manager only. It doesn't always cover theft perpetrated by the management company's principals or owners. So basically what fidelity insurance is, it's theft. It's insurance against theft and fraud of your association's funds. So for example, let's say that you have a self-managed association and the general manager for the association, it is discovered that the general manager has been taking association funds. And after going through the procedures that you would need to terminate that person and not giving them access to any of the association's funds, there'll be an evaluation. Okay, how much money did this person really take from us? And once we have concrete evidence about how much money was embezzled, we should be notifying our insurance carrier right away if we discover that there's potentially fraud or embezzlement by a board member or by your property manager. Then we go to the insurance company and provide the information to them, and then they may pay out under the fidelity insurance. And so this is an added layer of protection in the event that, a manager or board member, or maybe even the management company principals that are managing your association, if there is theft, fraud, or embezzlement of your association funds. So again, kind of the three areas of insurance, just as a quick recap, that your association really should have are directors and officers insurance, D&O policy, property insurance, and then fidelity insurance or fidelity bond. One little practice pointer, usually there's not that big of a jump in how much more it goes up to have a little bit more coverage. So it's something you'll want to evaluate, like the difference between a $1 million and a $5 million D&O policy might only be a couple $100. It might be well worth the money spent, especially if you're thinking about something that's controversial, like passing a special assessment or you're getting ready to do a general master plan for your community and it's going to be controversial. Kind of the same analysis on fidelity insurance. Most policies that we see, there's only like 50 grand in fidelity insurance. So you really want to look at what sort of cash on hand you have in your accounts, and do you have enough coverage to protect you in the event that there is theft, fraud, or embezzlement of your association's funds. And you should ask your agent, hey, can you give us different price points for how much our premium would be for different amounts of fidelity insurance? Let's see. Again, how much is enough? Be sure that you're checking your association's documents to make sure. A little bit about shopping for insurance. Again, 60 days before the renewal comes up, you're going to be receiving a notice from your insurance carrier as to whether or not they're going to renew or not renew your policy. This is a discussion you should definitely have with your management company. And I think there's an assumption, probably because we're all so busy in our industry, that if the comes back that you're going to have a renewal of your policy, you don't yet know what your premium's going to be, but they're not going to non-renew your policy. I think there's kind of a tendency just to sit back and do nothing. And I think as a board, you need to be proactive 60 days out prior to your policy renewing, because, if you're going to shop the rates for insurance companies, that 60-day window is like your game time. So what I typically see with associations is there's no shopping for different rates, and the management company and the board are not communicating 60 days before the policy is set to renew. And basically what happens is about a week before the policy premium is due for the renewal, the board's asked to sign a check. And there's basically no research regarding, hey, can we get a policy that might be cheaper, a better fit, more coverage, lower deductibles? There's no research on it. You get what you get and you don't throw a fit, and because there's no time to go and research it. So really, as a board, a good best practices pointer for today would be know when your policies are up for renewal. And in that 60-day window, you should be reaching out to your agent and finding out if they can shop this and see if there's another insurance company that might be a better fit for you. It might be a broker, an insurance broker who might be doing that for you as well. Okay, let's see. What are some things to really watch carefully on insurance issues? Well, first thing I want to mention is notice. So I talked a little bit about under the fidelity bond, notifying the insurance carrier if you think that the perpetrator, somebody, a board member or manager has stolen funds from you. But this notice requirement is really important. It's probably one of the most important things I'm going to say here today. So if your association is aware of a possible claim that may be filed against your association and you're going to be turning it over to the insurance carrier, you likely, like 99.999% chance, are going to have a requirement under your current insurance policy to notify the carrier of a possible claim against your association. So when do we do this? So the example I gave you, if we have discovered that there's been fraud or embezzlement of association funds, you may not know how much yet, but you smell that there's a problem here and there's adequate evidence, you should notify your carrier of this, and your attorney can help you do that. If you're aware that there was a bad accident in your association, I can think of one in particular within the past 12 months where there was a death in an association due to a traffic accident, and there was some thought that the way that a contractor had placed a trash receptacle had contributed to that, and the association hadn't required this contractor to move it to a more safe location. In a situation like that where, okay, there's a serious injury and, it's possible that we could be sued as an association, we should be notifying the insurance carrier. And anytime you have a situation like that, you really should be talking to your legal counsel. Hey, this happened over the weekend. Can you think of anything that we need to be doing to make sure that the situation is handled properly by the association? So I would say notify the insurance carrier of a possible claim. Number two, make sure that that dumpster, like an example, is removed. Make sure that you're talking to our security personnel and our patrols, that if they see something like this in the future, that the owner should be contacted immediately and it should be moved. I mean, just different things like that are very smart to do. Another time that you may have to notify the insurance carrier of a possible claim is if an owner says, I'm going to sue you. We hear that from owners sometimes when maybe we're involved in a dispute with an owner regarding an owner's violation, or maybe the owner isn't paying assessments or fines, or they're aggrieved by an architectural decision and they say, I'm going to sue you. That is the time that you definitely want to be notifying the insurance carrier of a possible claim. What's the consequence if you don't notify the insurance company of a claim and you're aware of it? It's possible that the insurance company will deny coverage because they weren't timely notified of the claim. Making good decisions on when to notify the insurance company is a very important skill for your board and your management company. And you should be consulting with your legal counsel and your management company and also your insurance agent if you're unsure about whether or not to provide notice. Let's see, what would be some other problem areas? Deductible, especially for condominiums. A couple of thoughts on deductibles. So a trend that we're seeing with condominiums is for damage claims. What associations are doing to lower the premiums is that they're making deductible really high. So let's say you have $1 million of coverage, property damage coverage in your condominium, but the deductible is like 60 grand or 50 grand. What that means is that the association is self-insured. That means they're paying all claims up to 50 grand. And then any large claims over 50 or over are going to go to the insurance carrier. So you really want to think through deductible because there is a science to it, right? It's a game. If you're making your deductible so high to lower your premium, what if there are 15 claims that are under 50 grand in that premium period or the year that you have the insurance policy? You may end up paying a lot more than you would have if you had just gone with a lower deductible. Deductibles are something that there definitely needs to be some thought put into it and discussion with your agent and your board, your management company, and your legal counsel. Another issue that comes up is who pays the deductible. First line of defense would be I look at your association's documents to see if there's a specific provision on who pays the deductible. Let's give an example. Let's say that you're at condominium, a pipe breaks. It's considered common areas. It's not pipes in the wall, but it's not in the airspace of the unit in a condominium. So it's the association's responsibility to maintain this pipe. For whatever reason, the pipe breaks. It's not the fault of the owner. And there's significant water damage to the unit owner due to that pipe breaking. That's typically going to be the association's responsibility to pay that deductible. And how deductibles typically work when there's an insurance claim is that the insurance company, when they're paying out the claim, they just short how much they're paying you by the deductible amount so that they know that they get paid. Let's flip it. And so at the end of the day, you may not have as much money to work with because the deductible will be dead and the association may have to make up to put that property back to the condition that it needs to be put back into. Let's switch it and say a very common thing that we see is maybe inside the airspace of a condo, an owner has some sort of a water incident, whether the bathtub overflows or the toilet has a leak and inside the airspace of the unit, or the disposal or water purifier. I mean, there's all kinds of different water heater where the association is not at fault, but a claim is being made on the association's policy because the association's policy is primary and common area has been damaged. In those circumstances, the homeowner typically will be responsible for the deductible because they're at fault, because the root cause of the water damage or the fire, could be a grease fire from cooking, is the fault of that particular owner. So again, there needs to be some analysis on the deductible at the time that you renew your policy, and then also when claims are being made. Remember that if an owner asks to, if there's some sort of a damage claim that they're making and they're coming to the board definitely needs to take that request seriously. If the board isn't responding in a timely manner, the owner can go directly to the insurance company and make the claim themselves on our policy, the association's policy. So you definitely want to respond in a timely manner if an owner is coming to you as a board to make an insurance claim. A couple just tips to think about one more thing I want to mention. If you have direct employees for your association, meaning like you have a maintenance man or a handyman, or you have on-site staff and they are not employed by a third party that's an independent contractor. If you have direct employees, you have to have workers' compensation insurance in Arizona. And many boards overlook this coverage, but you do need to have this coverage if you have direct employees. So anyone on your payroll as a direct employee, you have to carry this workers' compensation insurance. It's not that difficult, but it's through the state of Arizona. So you want to make sure that you look into that and be aware that is a requirement. Okay, let's just do some quick insurance tips before we move into our second topic, which is safety. Know when your policy renewal is. That's a good question for your management company, and calendar that date. So 60 days before that date, you should be thinking, okay, we need to be getting together our strategy for our insurance renewal and our premiums. Make sure that you read the provisions in your association's documents so you understand what types of insurance you are required to carry as a board. Research to determine if your insurer is on solid financial ground. There are different grades for different insurance companies, like A, B, C. You want to make sure that the insurance company that you're using has a good rating. Be proactive about risk management. The best way to reduce premium costs is to limit the number of claims that are filed on your policy. Some claims are unavoidable, but other claims you may want to have a strategy that you're paying out of pocket versus making an insurance claim. If you've had a number of large claims recently, and then you've got a small claim, that may be one that the board pays out of pocket so that your insurance doesn't get canceled. So there definitely is a strategy on risk management on your policy, and your legal counsel, your management company, and your agent can definitely provide you with feedback on that. Even if insurance coverage is in place, be proactive. We talked about shopping the insurance coverage. If there are changes in exposure to risk, and also to kind of price check and compare what's available in the market right now. decide what coverage you need first, and then compare apples to apples. If you are going to change carriers, insurance carriers, make sure that you ask the agent to certify the new policy coverage in writing. That statement should include apples to apples comparison, listing the coverage from the old policy, the new coverage, and any coverage from the old not provided in the new policy. Just so that if you are changing insurance companies, that you're not dropping Fidelity insurance by mistake and not realize it. Have a claims policy procedures and follow them. Oftentimes, insurance claims are emergencies, especially when there's water or fire incurred. And so pre-talking about them as a board, like how are we going to handle this if this should happen, is really a smart idea, so that claims are processed in a timely and efficient manner, and that we can mitigate any damages that may occur, especially with water damage. The sooner we can get in there and get that cleaned up, the better. Let's see, for condominium owners, make sure that we're talking about and educating the homeowners in your association about what the association is covering insurance-wise and what the owners are required to carry as owners, so that they have the proper insurance as well. And when an insurance company receives notice that, hey, your policy is not going to be renewed, you need to act promptly. You need to talk with your agent, you need to talk with your management company and your legal counsel to come up with a strategy on how to best handle that difficult situation. Okay, that's it for insurance. It's kind of a dry subject sometimes, but honestly, when you give the examples and you talk about how serious issues can be if you don't have insurance right, it's something that every board really needs to be focusing on and thinking about to adequately protect them. Okay, let's talk about community safety and preventing crime and limiting liability for your association. Something that we talk about from time to time with boards is, how do we handle property crimes that happen in our neighborhood, or how do we handle it if there's been increase in burglaries, robberies, or maybe something really horrible in your association has happened where there's a perpetrator that's, may have attacked people. I think according to the United States Department of Justice, a property crime is committed every 3 seconds, and a burglary takes place every 12 seconds. A motor vehicle is stolen every 20 seconds, and a murder occurs every 23 minutes. Those statistics are scary. And I think a lot of associations don't know what to do if there is something like a crime or a safety issue within your association, because it's different from maintaining your association. It's kind of a new issue. And so what I'd like to do today is give you some tips on how to handle it if you are seeing increase in crime in your community, and just know what your responsibilities are as a board. So one of the fundamental issues regarding liability for associations when there's crime or injury or something like that, or property damage, property theft, is what duty does the association and its director owe to owners and residents and guests that live in an association or they're visiting an association. And the Arizona Supreme Court, in a case that was decided many years ago, applied a standard that's very similar to a landlord-tenant standard. And basically, this is the Martinez versus Woodmar 4 case. And this is kind of an interesting case. I don't know exactly what year it was, but it was when I was a much younger attorney than I am right now. So I was probably in my 20s. Now I'm 55. So this is 25 years ago, at least. So in the Martinez case, the Arizona Supreme Court found the association had a duty to use care and to maintain the safety of the common areas. And so what the facts were on this case, kind of an interesting case, was a plaintiff, person who was suing the association, who was a guest of a tenant, sued the association, in this case Woodmar for condominium association, after the plaintiff was attending a graduation party as a guest of a tenant at the condominium complex. Sometime later, after the party, the plaintiff and 2 other guests returned to the complex's parking lot, where they found a group of local young people sitting in one of the guests' cars. There was an altercation on the property of the association in the parking lot, and plaintiff was shot in the back. Now, mind you, this person, again, was a guest of a tenant, and they sued the association. The plaintiff, his friends, and the live-in security officer recognized the group as a gang of young people from a neighboring complex that would often gather in the parking lot to take part in illegal activities. In the past, security guards had broken up this group of mischief, but because of budget constraints, the association's security guard that used to patrol the complex for limited evening and early morning hours the hours had been reduced so that the guard wasn't there at the time that this occurred. The plaintiff sued the association, claiming that the association was liable for failing to prevent the attack on that particular guest of the tenant. So interestingly, the Arizona Supreme Court, when this case was eventually appealed and was in front of the Arizona Supreme Court, found that the Arizona Court of Appeals mischaracterized the case. And while the association had no responsibility to control the shooter, a duty existed on the part of the association concerning the property. And the court held that any common areas under the exclusive control of the association, a condominium association has the same duties as a landlord. And what that means is that the court in this case held that the association was responsible, and was going to be financially liable by their insurance company because it found evidence that the association knew that gangs gathered in the parking lot and the other common areas. They knew that they were engaging in criminal activity. They were warned by their prior security guard of the need of a 24-hour patrol. They hired a second security guard to deal with this issue, but then later terminated him because of the expense of having the security guard on premises. And the association knew that other complexes had hired off-duty police officers to patrol. So the Martinez court, the Supreme Court, found that the association should be held to the same standard as a landlord, and said that the association had an affirmative obligation to exercise reasonable care to inspect and repair such parts of the premises for the protection of the lessee, and the duty extends to members of the tenant's family, employees, invitees, guests, and others on the land in the right of the tenant. So really kind of a landmark case in Arizona that makes it a duty for boards to keep their common areas safe and free of crime. But again, it would be that foreseeable and preventable dangerous activities on the land. That's what the association has to be mindful of, right? And so the association in this case had a duty to their owners and their guests to maintain the common areas safe from foreseeable dangers. And so the facts were kind of unusual in here because they knew about the dangerous gang activity, and the board ultimately reduced the security coverage that they had in their community. So in light of this case, what should associations be thinking about? What are some practical considerations so that you can limit your liability? Some on-site suggestions that we have for you: install controlled entry systems. So if you have guard gates, electronic gates, telephone entry systems, those are all helpful in keeping your common areas safe and free from crime. For some associations, budgetary constraints are not going to be able to allow you to do that. But be careful. Like if you're one of those associations that maybe you have a gate access to your community, but the gate is always broken and it's always open, that is definitely a liability. You need to get the gates working and having it in operable order, because there's an expectation that that gate is going to provide controlled access so that not just anyone can come in. You may want to consider having a security patrol, and this could be in the form of hiring off-duty police officers, a security company. You also may want to consider having a neighborhood watch group. There's different levels of money that you may need to spend. And again, these are kind of suggestions I'm giving you in the event that you're seeing increase in crime level in your association, like you're hearing reports that people's cars are being broken into, or that people leave their garage door open and now things are being stolen out of their garage. One thing that I think is a great suggestion that when I attend board meetings, sometimes I see this, or annual meetings, I see this. The board does like a safety and security report, and they'll have like a local police officer from the precinct that's closest to the association come in and talk about crime in the surrounding areas, and maybe even a crime analysis of what's going on in your community. And they can talk about what are some things to prevent theft and crime. So the most common things that I hear would be remind owners to close your garage doors at night. Remind owners that if you're out of town, use, different battery operated lights or different devices so that lights turn on and off. So it looks like somebody's home. You know, don't leave valuables in your car that's parked in your driveway, because that's going to be something that's going to be enticing to a criminal. They're going to want to break into your car to get your purse or your laptop. Some other things that boards do are they also install surveillance cameras on the common areas. This is kind of tricky because most of the time that camera isn't going to be monitored 24/7. You don't want to give a false sense of security to your owners if you're putting up cameras. We see a lot of associations put cameras up at pools, and that's not monitored 24/7, but they do it so that if there's damage to the pool, they can go back, rewind it, see who caused the damage. So that's kind of a sticky wicket, because even if you have the cameras, you may not be able to identify who the person is that did this if they don't live in the community. And also, you want to make sure you notify the owners that, hey, this isn't monitored 24/7 by somebody. So in the event that there is something serious going on, you need to call 911. Having proper lighting in an association is also a deterrent for crime. So using motion sensors, making sure that lights that have burned out are properly replaced in a timely manner, that does provide an extra level of coverage, in that maybe a criminal is going to be less likely to come into your neighborhood because it's really well lit. Reducing the size of shrubs, particularly in front of front windows and other areas, also can eliminate hiding places for criminals. There are some programs that an association can implement that will be helpful to limit crime and liability for your associations. Creating neighborhood watch groups, security patrol in your association, having signs in the windows, and you can work with your local police precinct to help you set those programs up. And it's all volunteers that run it, can be a deterrent to criminals. Having different programs that you may set up in your association to raise awareness, like a bicycle registration program, an out of town watch program, having a bi-monthly newsletter, or a newsletter when you need it that just kind of talks a little bit about reminders, keep your garage door shut, or letting people know that, hey, there have been a few incidences in our community. Please be aware of your surroundings if you're walking alone at night, etc. Also, putting neighborhood watch signs at the entrances to your community can be a deterrent to criminals, and have those well lit so that they know that we have these type of things in place. Last but not least, some suggestions for the board. Don't misrepresent the quality of the service. We don't want to overpromise and underdeliver. So be honest with your homeowners. This is the type of security system that we have in place. We don't have 24-hour monitoring of the cameras, etc. Create a crime prevention handbook for your association if you think that's something that you need. There's a lot of crime, maybe suggestions and tips. Have a plan of action if problems develop. Implement additional security measures, and notify residents that they need to take steps to protect themselves if things are occurring in your neighborhood. Don't reduce security without talking about it with your legal counsel, your management company, because like we saw in the Martinez versus Woodbar case, that really was a problem in that lawsuit and created liability for the association. If you are going to reduce security for your association, maybe because it's no longer necessary, just make sure you're notifying your residents of the board's policy change on that. And then most importantly, obtain adequate insurance. So if something does occur on the association's property, we have adequate coverage for the association. And really these suggestions, they're our cheat sheet. We have a great cheat sheet on this topic. You may want to, as board, take a look at these issues and the suggestions that we have in the cheat sheet to help you create a more safe environment for your community. Okay, now we're on to our question period. We are right on time today, which is great. And we're going to be switching now to our questions. It looks like we have 27 questions as of right now. Okay, let's see. The first question is association's property to access our homes. Let's see here. Okay, so our association must cross another association property to access our homes, and we're required to pay their annual assessment to use their roads. I requested to ADOT that our entrance gate be moved to where our emergency exit is, but they denied it due to safety and traffic concerns, even after I provided all necessary paperwork. I read Arizona law and wonder if it prevents us from being denied property access, since these are the only two entry points for our association. Can this law help us stop paying the assessment to the other association, which keeps increasing each year? So great question. A couple thoughts on this. There's probably a written agreement or maybe even a recorded easement that allows your association to use the other roads to get to your association. And if I had to guess, the city that you live in that was a requirement for your association to be built. And usually there's a requirement to have two, like an entry and exit for emergency vehicles in order for the development to be allowed to be built. So if I had to guess, this is a requirement that the city has. You probably have a contractual obligation with this other association. And so it's hard for me to comment on it without seeing all the paperwork, looking at the easement, looking at any sort of written agreement there was for financial responsibility for using their roads to get to your association. And then also it's likely that that back exit that's part of your association can't be changed into a front exit because of the way your association was set up. But if you want more information on that, you're welcome to reach out to our firm. I'm happy to take a look at it. Okay, next question. Is there any statute of limitations when it comes to a homeowner's violation of the ARC guidelines? For example, if a homeowner planted a tree that was not on the approved list, but years later received a violation notice to remove the tree, does the homeowner have to comply with the notice and remove the tree? Since a substantial period of time has elapsed, does the owner have to comply with the architectural guidelines? So great question. If the trees existed for more than 2 or 3 years, you're really not going to be able to enforce that under the doctrine of waiver or latches. So I think that's kind of a good litmus test. You can check to see how long the tree's been there. You can look at aerial records through Maricopa County tax assessor. Those are listed on that page through a link. But if it's existed for more than 2 or 3 years, you're not going to be able to force that owner to remove that tree or whatever. Now, if the tree dies and replacing it with something else, that's when you would be able to say, no, you need to follow the ARC guideline. Okay, next question, number 3. Can you provide some insight on how HOA boards conduct online voting emails to approve an item in between regularly scheduled board meetings and later ratify the decision at the regularly scheduled board meeting? Can you share your thoughts on doing this? So yes, I can. First, we have a great cheat sheet on the Arizona open meeting law, and this is a really good overview of your requirements under Arizona law that anytime a quorum of a board is meeting to discuss association business, it really needs to be an open board meeting where the owners are notified 48 hours in advance via posting a notice and the agenda of what's going to be discussed at that meeting. That is the law in Arizona. Now, some associations and some management companies are encouraging associations to vote electronically by using an action by written consent or action by unanimous consent outside of the board meeting to make decisions. And then at the meeting after the next open board meeting, they ratify that decision. That's a risky thing to do, in my opinion, in light of the fact that the open meeting law is very specific. Really, the only time I would be using email to vote on things outside of a board meeting for a board would be if it's an emergency, a true emergency, where you cannot wait 48 hours to notice a meeting and a decision needs to be taken to protect the association. So I really do not encourage clients ever to make decisions by email outside of a board meeting absent emergency circumstances. There are two cases that have been decided by administrative law judges, which support my opinion on this, that you shouldn't be doing this unless it's an emergency. Okay, next question, number 4. This is in Arizona. I thought the amount was under $2,000, but I think a law was just recently passed with increasing the amount to a lot more. Is this correct? Can you explain? Okay, so this is regarding foreclosures, and we talked about this at the beginning of the presentation today. So starting September 26th, which is the effective date, I'll check to make sure I've got that date right. Starting September 26th, yes, Friday, September 26th, there's going to be a whole bunch of new legislation that's going into effect for things that we talked about at the beginning of the presentation. And if you're a planned community, it's going to be more difficult to foreclose. So what you want to do is look at Senate Bill 1494. If you're a planned community after September 26th, like we said earlier in the presentation, we can't foreclose. until the minimum assessment delinquency time period is 18 months past due. And then, or $10,000 is owed. So that's going to be the law starting September 26th. Okay, question number 5 from an owner. We had to condense this because it was a little bit long. So many homeowners in our community are concerned about poor HOA management, declining property values, and serious maintenance violations. Violations have gone unchecked. Homeowners are divided on assessments, and a high percentage of rental units raises concerns about financing and being able to sell our units. Given these circumstances, what legal and financial risks do homeowners face if the HOA fails to maintain the property and enforce its governing documents? So the risks but legal and financial risks. So legal risks, the homeowners aren't going to be sued for anything, but the association potentially could be sued, and that could have a direct impact on the owners in the association in that if you have a lot of insurance claims, your premiums are going to go up, so your assessments may go up. Or if things aren't being maintained over a long period of time and there's a bunch of deferred maintenance, there's going to be special assessments, and every owner is going to have to pay for the special assessment. You may not be able to sell your homes or your units if you live in a condo. These are all problems that potentially will affect you. So not to be a doom and gloomer, let's look for some light at the end of the tunnel here. I really suggest that you consider running for the board or becoming more vocal as a homeowner to try to get positive change in your community. Okay, question number 6. Also, we had to condense this particular question. A rental property regularly violates HOA parking rules by keeping its garage unusable for vehicles. Probably they got a bunch of stuff in the garage, right? Storage. They fill their driveway and park up to 7 cars on the street, sometimes blocking the fire hydrant. The number of vehicles suggests possible over-occupancy in a 3-bedroom home, raising security and code compliance concerns. Given these circumstances, is the property owner responsible for correcting the tenant's violations? And can the HOA or city enforce limits on parking, occupancy, or safety hazards in rental properties? Well, a couple of things that you can do here. Number 1, you can contact code enforcement for the city that you live in and have them investigate to see if there are any code violations. Second thing that you can do is notify the association of your concerns, and the association can cross-check their documents to see if there are any violations of the documents, the CC&Rs, bylaws, rules of the association. And if there are, they can contact the landlord owner regarding the violations, potentially fine the landlord owner, and maybe even file a lawsuit if that's something that's economically feasible and a good idea. So you do have different options here. We have a great cheat sheet on how to work with rental properties that I would encourage you to take a look at. You can find that on our website at mulcahylawfirm.com, or we're going to be sharing it with you right here in this presentation. Okay, question number 7. How would we go about changing our HOA president? Okay, it looks like you're not happy with the current president of your association. So look at your bylaws. Typically in most bylaws, a majority of the board can remove an officer from their officer title, but it wouldn't remove the director so when you're president of the association, maybe you're a president and then you're also a director at large for the association. So you can strip them of their title by a majority vote of the board, but you can't remove that person from the board altogether without following the procedures under state law, which require like a petition and a special meeting of the membership and a certain percentage of the owners to remove that director at large from office. So short answer, you can, as a board, a majority of your board can remove the president's title, remove them from that position and appoint somebody else, but that person will still be a director at large on the board. Okay, next question. Now, can you talk a little bit about grandfathering? Is it a good idea or a bad idea? I'm not sure what context that you're raising grandfathering in, but if I had to guess, maybe you're talking about grandfathering as part of amendments to an association documents. If that's the case, we have a great cheat sheet called Amending CC&Rs. It's a 5-step plan. And if that is the case, you may want to take a look at that. So whenever we're doing an amendment, especially in light of the Callaway case, we're definitely thinking about we want to grandfather existing owners so that we don't have a legal problem under the Callaway case, changing the use of a property without 100% approval of the members. And so what is grandfathering? Grandfathering means, like, let's say that we're going to pass a rental restriction in your community. Your CCNRs do not have anything regarding rentals. So under Arizona law, an owner would be allowed to rent their property. So let's say we want to put a minimum 30-day rental period on renting in your community. Under the Callaway case, it's our firm's opinion that if you currently have availability and you're allowed to rent according to the way that your documents are written, that would be a change of use and you would need 100% approval of the members. Now, a crafty way to get around that would be to grandfather all existing owners in the amendment. So the language should say this amendment only applies to future owners that purchase after this amendment is recorded. So we would get around the Callaway ruling, which would require 100% approval for a change of use because something isn't foreseeable. And so basically what would happen in that case is that any new owner who's buying would know it'd be foreseeable to them that, hey, this provision exists, and it would be legal under the Callaway case. And then all the existing owners who are owners at the time the amendment is recorded, they would all be grandfathered and would still be able to have no restrictions on their leasing if they chose to lease their property in the association. So is it a good idea or a bad idea? I mean, it's a tool to move forward with progress in your association and to limit your liability. So yes, we do use it pretty frequently. Okay, question number 9. Our master association will not share violation notices with our sub-association. They say the violation notices are confidential. Is this accurate? This goes to the records request laws in Arizona for condominiums and planned communities. So any book and record of the association is, generally speaking, should be available for an owner to review after they make a written request to the board. There are some exceptions to that, like if it's a legal matter or your advice from legal counsel, it's personal health or financial information about an owner. A violation letter could potentially fall under the personal health or financial. It could potentially fall under litigation for the association. So I don't know that much about the situation where I can really weigh in on this. What we typically will share will be like a violation list without names and with redacting the addresses. That way we're not sharing any personal information. Maybe that's an option that you can do to see if you can request it, doing it that way so there wouldn't be any personal information shared. Okay, may a board refuse to record open meetings is question number 10. So yes, if your board doesn't want to record open meetings, you don't have to. It's not required under the law. The new legislation that's going into effect September 26th just talks about if you record, you have to keep it for 6 months and then give it to the owners. They request to see an unedited version of it. You have to provide it. But you're not required to record open board meetings. You are required to take meeting minutes of every open board meeting and every executive session meeting. Okay, question number 11. There are no restrictions in the CCNRs concerning committee membership. Can or should the community manager be the second member of a 2-person governing documents committee? I guess can or should, I guess why would they be, would be kind of what I'm thinking. Usually the manager is just there to be at the will of the board. I typically do not see any managers in 29 years, almost 29 years practicing law, where the manager is that involved in a document amendment provision, a document amendment committee. I think it would be better to have homeowners, or even better, board members to be on the governing documents committee. Number 12, what are the pros and cons of using a professional debt collection agency that can report to credit reporting agencies for homeowners with long-term debt to the association? Our management company has been unsuccessful in collecting the debt. Okay, the pros would be that they're probably going to do it at no charge. The cons are that these professional debt collection agencies will send 1 or 2 letters and then they give up. So they're only looking for the fruit that's ripe and ready to drop. So people who are ready to pay, they're not going to be making any extra effort to go after the hard people to collect from. They're looking for easy money fast, in my experience. If they are reporting to credit agencies for homeowners, it could be a liability for the association because if the debt's paid and the credit company isn't notified, we could be sued under the Fair Credit Reporting Act. The association could be sued. I really think the better approach here truly would be, instead of handing it over to a debt collection agency, would be to just make a decision. Is this debt collectible? And the best way to do that, like our firm regularly looks at files for associations, and we will say to them, okay, here's the credit snapshot of this person. They're a former owner, they're in bankruptcy, they've got a ton of debt. This is probably somebody we're never going to be able to collect from. Maybe we recorded the judgment, and when the judgment is up for renewal after 10 years after it's been decided or issued by the court, then we reevaluate the credit then. But right now, this person does not have good credit, and maybe we do, maybe we don't renew the judgment at the end of the 10-year period based upon the credit. I think having somebody who understands collections and who can quickly look at a file and say, this person's uncollectible, or this person I think is collectible and why, is a really good decision. You may want to once you make the decision, then maybe send it to the collection agency, but be careful on that Fair Credit Reporting Act. If they're reporting to credit reporting companies, you want to make sure that whatever they're reporting is accurate. Okay, next question, number 13. Can a board member file the ACC report? So the Arizona Corporation Commission report. So short answer on that would be yes, but the board member is going to have to ask, there are certain questions at the end of the ACC report that have to be answered by all board members. And so they need to poll the board members so that they can adequately and properly fill that ACC report out. But yes, board member can do it, the manager can do it, your attorney can do it for you, as long as all board members are consulted and answer the questions that are required to be answered on that report. Okay, question number, and remember that ACC annual report needs to be filed once a year. So you should have that on your radar, that is something that your board needs to do every year so that you keep your corporate status in place, because that corporate status is a shield around the corporation so that the individual owners can't be personally sued. So you always want to keep that shield in place. And the way to do that is to file that ACC report every year. Now, every association has a different due date. You should go to the Arizona Corporation Commission website and look up when your association's annual report is due. And they have a little email reminder system that you can put your email address in so that you are notified when the annual report is due each year prior to it being due each year. Okay, next question. Let's see. Our bylaws state, number 14, our bylaws state that the president shall be ex officio chairman of the board. They also state that in the absence or inability of the president, the vice president shall have and exercise all authority of the president. Our bylaws do not make a provision for who should chair the board meeting if both the vice president and the president are absent. If we have a quorum with enough of the board members attending, can we still hold the board meeting? So short answer on that would be yes. Quorum of the board, you can still make decisions. And then whoever's there, the quorum, you just decide among yourselves who's going to act as the chair for that meeting and make sure meeting minutes are taken. Now, I want to just mention one thing. Don't be sneaking around and doing board meetings without the president and the vice president because you don't want them there. Every board member should be provided notice of the meetings, and all owners obviously should be provided notice under the law 48 hours in advance of the meeting. Okay, next question, number 15. If you share the screen to show a picture during a Zoom meeting, does that screenshot have to be captured as part of the recorded meeting? Well, it should be captured. So I'm wondering if it's not, if you share the screen, it should be with the recording. So it should be part of the Zoom meeting. I guess, does it have to be in the minutes? Probably not. If it was discussed, probably not. It would be best practices to include it with the meeting minutes, but I don't think there's a requirement to do that. Okay, number 16, is it necessary to amend the CC&Rs to validate the use of Zoom for our board meetings? So short answer on that would be no. Number 17, could you go over the new declarant law regarding turnover? I'm not sure what law you're talking about. I think maybe you're talking about the legislation that went into effect last year. And if you go to our website and go to our cheat sheet page, you can look at our update from 2024 legislative session, and it will talk a little bit about the different requirements for turning over association control from declarant control to homeowner control. Question number 18 from a treasurer. My board wants to make an exception to our CC&Rs. Specifically, they are going to allow one unit to park a utility trailer in the community parking area for the winter. Our CC&Rs state no longer than 48 hours can a utility trailer be parked. Is the board allowed to make this sort of an exception without a membership vote or change to the CC&Rs? We have 3 board members. All 3 were appointed and not elected. 2 want to allow this exception. 1 does not. I mean, if it's in your CC&Rs that this shouldn't be allowed for longer than 48 hours, I don't think that this is an exception your board should make because you're contractually obligated to enforce your CC&Rs. Okay, next question 19. I realize that a board member does not have to sign a code of conduct. And have you seen this and how do you handle? As you might expect, this board member is very antagonistic on everything. Conversation with the board member has not been accepted or approved. Okay, so we have a cheat sheet on code of conduct on our website. Just go to mulcahylawfirm.com and you will see the code of conduct cheat sheet there on our cheat sheet drop down on the homepage. So we get into situations with the code of conduct, typically when there's bad behavior on a board or people aren't getting along on the board or can't get anything done on the board. And so we bring out the code of conduct and basically it just reminds everybody these are your obligations to the corporation and you have a duty of care, duty of confidentiality, duty to avoid self-dealing. And we ask that the board members sign it. But of course, what typically happens when we bring that out, the board member that is the biggest problem refuses to sign it. So in those circumstances, what we do is we just have a majority of the board adopt it. And we don't have people signing it. We just have a majority of the board make a motion to adopt this for the board. And does it really add anything extra? Probably not. It's just a good reminder to all board members that you should be adhering to your fiduciary responsibilities to the corporation, upholding the CC&Rs, and again, having proper duty of care, keeping things confidential, and also avoiding self-dealing as a board member. So best way to handle it, I think, is have a majority of the board approve it if not everybody on the board will agree to sign it. And also then if this person starts to violate it, then have your attorney write the board member a letter outlining what their deficiencies are and why they are not adhering to the code of conduct that is expected and required for board members. Okay, question number 20. I'm just going to do a quick check to see how many total questions we have. Looks like we're up to 32 questions. So we have a homeowner who about 4 years ago put a massive 4-foot cross in his front yard. And as an HOA, we've given up because fighting him was starting to drain us financially in legal fees. The city hasn't been any help, as they say there is no precedent. This house also puts very strong religious script on their car's sunshade and then backs the car into the driveway. The house next door is trying to sell, but per their real estate agent, potential buyers are not even entertaining showing once they see the religious stuff they would be living next to. The seller has reached out to the board for help. Any ideas or thoughts? Well, it looks like this violation has existed for 4 years, and so it may be very difficult to enforce this. And there may be some fair housing issues that might not, we might not be able to manage that because it could be a violation of the Fair Housing Act. So I do think your association's really in a pickle on the situation based upon the amount of time that's lapsed, and there probably isn't too much that the board can do about it at this point. Okay, question 21. What is the typical order of process before sending a homeowner to the attorney or involving the attorney? And should a homeowner know upfront what the attorney's legal fees will be? So there is a law that requires that prior to a matter being turned over to the association's attorney, that like for unpaid assessments, that the association write a letter to the homeowner and say, hey, your file is going to be turned over to the attorney if you don't pay this debt now. So there is that law that's out there. So typically what will happen in an association is, whether it's a violation or assessment collection matter, the association board or the management company will write a letter or two, and then it gets turned over to the attorney. And no, the homeowner typically will not know up front, meaning we don't send a fee schedule to the homeowner, but if we're collecting money from the owner, we will include a breakdown of what the amounts owed are, and that will include how much the attorney's fees are to date for that particular owner. Question 22. How much D&O insurance do you recommend an HOA board carry? Our board has $5 million in coverage. I would say I don't know how large your association, but that is typically on the higher end. And so it's probably okay. You might want to talk to your insurance agent and discuss whether or not that's adequate coverage for your association. But it looks good from my perspective. That's in the higher range that we see for associations. Okay, 23. Should an HOA have an additional insurance policy for workers' comp for its board and committee members and crime insurances, or are these both covered under the property liability policy? So I don't think that the workers' comp would apply to the board and committee members because they're not being paid to serve or to work for the association. Crime insurance, I'm guessing that you're talking about like cybersecurity, which a lot of associations are getting now. So that's something that you can talk about with your agent. Is it included in your current policy or is that a separate policy? Question number 24. How can you make the member or owner responsible for the deductible if they were the cause of the damage or claim? Well, you have to look at insurance claims on a case-by-case basis. But if the owner has a grease fire and they burn down their unit, there is going to be, of course, the association's policy is typically going to be the primary, and the homeowner's insurance policy is going to be secondary. But typically, if the root cause, whoever's the root cause of the problem, in this case, the grease fire, is going to be responsible for the deductible. And like I said earlier in the presentation, the deductible is just deducted from whatever the total amount of money is given by the insurance company to the association under the policy to pay for repairing the damage. So how can you do it? It's really the board just notifies the owner that this is how this is going to be handled. Okay, question 25. In my condo association, the HOA is responsible for roofs and skylights. Recently, the HOA replaced the skylights, but some are already failing. One owner has reported her cracked, leaking skylight 3 times over 6 months. During a recent storm, water damaged her ceiling drywall. Property management told her it's her responsibility to fix the drywall, but she feels the HOA should pay since she reported the issue and the skylights were poorly installed by the HOA's chosen contractor. How can she get the HOA to cover the drywall repairs caused by water damage from the faulty skylight installation? It does sound like this is a situation where the HOA would be responsible. So I would write a letter I'd have this owner write a letter to the board, and if they fail to act, they may have to get an attorney to write a letter to the association. I don't think this is something that would be covered by insurance, but they're going to have to contact the board to get this paid. And if they refuse to pay it, then you may have to get legal involved, your individual lawyer involved to help the owner send a letter to the association board. Okay, question number 26. In our condo association, we had a per unit water deductible. A couple of months ago, we started having lenders require a special endorsement to our property policy with a max deductible clause that overrides the per unit water deductible. This additional endorsement is expensive, and many owners were upset with the board for adding an additional premium. At the time, 2 lenders would not fund if the endorsement wasn't added. Is this becoming more common of a requirement from lenders on conventional loans and others? We're really not seeing this on a regular basis, so it's not common in my experience. Question 27. We are in Sun City and our condos are essentially duplexes with open common area in the back, and there's no way to control who walks on our property. Do we need to put up signs that say private property and cite any ARS legislation? You certainly could do that if you want to. There's no legal requirement to do that, but if you're seeing a lot of trespassing, that might be a good thing to do. Okay, question number 28. Even though we have a bare walls insurance policy, an owner thinks the HOA should pay for the water damage caused by a broken pipe in her bathroom wall because her homeowner's agent told her it's the HOA's responsibility. What is the best way to handle this situation to avoid bad feelings among owners? Okay, so bare walls policy means that anything from the paint in is going to be the owner's responsibility, and anything from the wall into the airspace, anything that's not in the airspace of the unit is going to be the association's responsibility. So I don't know, it says a broken pipe in her bathroom wall. I don't know enough about that bathroom wall. Like, is it common area or is it a wall that's within the airspace of her unit? In a condo, typically the walls It depends on where the broken part of the pipe is too. Is it inside the airspace of our unit? So there's a lot of questions here that I can't answer this unless I know, more information on this. A good way to handle disputes like this is just take it right to your agent and talk about it with the agent, and then go back to the owner in terms of whether this is covered or not covered. And also, you may want to bring in your legal counsel to weigh in on it as well. After looking at your association's documents and then looking at the root cause, they might be able to give you a better interpretation as to whether or not this is insurance coverage for the association or the owner. Question number 29. We do not have direct employees in our HOA, but we have numerous volunteers doing work. Do we need workman's comp insurance for our volunteers? That's a really good question. I mean, they're not being paid, they're just volunteers. But the thing that worries me is what if they get injured volunteering? So you really want to be mindful of. I had an association once many years ago that was having volunteers jackhammer up the pool decking at the pool. Now, that is totally not a good idea. That is dangerous. You should have somebody who's licensed and bought into doing that, not volunteers. So I guess, are you wondering, I have volunteers that attend board meetings. Do we need workers' comp for that? No. I would really shy away from using volunteers to do anything that you should be using licensed and bonded contractors for. If a volunteer is changing a light bulb and they get injured, yes, they may have a claim against the association. The way to avoid having workers' comp insurance, which would be really very unusual for your volunteers, is just don't have volunteers doing anything that is really something that should be done by a vendor. Okay, next question, number 30 from Facebook. We just received a violation notice from the HOA 2 days ago. Last week, we put in an architectural request for some landscaping changes. At the board meeting last night, they announced that they would review the architectural request. They would not review the architectural request because we were not in good standing. There's nothing in our community docs that says they can do that. Okay, so if you put in an architectural request and there's nothing in your documents that says that, hey, architectural requests aren't reviewed if you're not in good standing or you owe money to the association, then yes, the board is not acting appropriately. I don't think I've ever seen a provision in 29 years, almost 29 years, where somebody cannot submit an architectural request because they have a violation on their lot or because they owe money to the association. So I think just you need to push back on that and just say, show me in the documents where it says you can do that. And I've talked to an attorney, and that attorney's opinion was that you don't have the right to do that. Okay, question number 31, also from Facebook. You mentioned executive meeting minutes need to be done, but are those available or should they be available for homeowners to view? So no, executive session meeting minutes are only available to the board to view. So homeowners cannot make a request to see executive session meeting minutes. Question 32, what's your opinion fee to a new sale, to new home sales that would be directly paid to reserve funding and can lower the fee of some of the same kind to be applied to rentals? Is there a limit on this fee applicable to new home sales and rentals? Okay, a couple thoughts on this. So we got a lot going on with this question. So yes, my opinion on this is that I think it's a favorable thing to have. We call it a capital contribution fee or a transfer fee. We have a cheat sheet on this topic. It's called transfer fees versus disclosure fees. There's very specific requirements in order to charge a transfer fee under Arizona law. So you have to meet all those requirements. Like it has to be in the CC&Rs. It has to touch and concern the land. It has to be directly given to the association. And so there are very specific requirements for that transfer or capital contribution fee. And I'm in favor of it. I think it's a good way to fund your reserves. Now you're talking about another fee for rentals. There's under Arizona law, there shouldn't be any fee other than there's a $25 fee that you can charge when there's a change in occupancy. And the owner has to provide certain categories of information, and we can charge a $25 fee for that. I don't know how much your association is charging for rentals, but there is a limit on that under Arizona law that your association needs to be mindful of. Okay, question 33. I may have skipped this question. I'm sorry if I did. My board wants to make an exception to our CC&Rs. Oops, I already answered this. So I did answer this already about the trailer. And I said that you cannot make an exception if your CC&Rs do not allow that type of trailer parking. Okay, question number 33. Now that we see homeowners installing commercial holiday type lighting permanently, they can activate the lights year round with pulsating or moving lights. We have a holiday lighting rule when Xmas lights must be on and turned off. Now, should we write an additional policy? Sounds like you may need to do that if they're keeping them up year round and they're activating them for different holidays like the 4th of July or whatever. Okay, last question for today, number 34. Our longtime lawyer that management company has used for advice is now retiring. If the board and management company hire a new lawyer, should this be brought to the attention of the membership? Also, the previous attorney would offer advice and the secretary or management would paraphrase the advice. I believe that advice without attorney letterhead is hearsay. Am I correct? Okay, lots going on in this question. So be careful, like you said, longtime lawyer that the management company uses. You don't ever want to hire a lawyer that is like the management company's that works for the management company, in my opinion, or that the management company is forcing you to use. And why is that? It's because who are they going to be loyal to if there's a dispute between the management company and your association, right? You want an independent person who's always going to be your lawyer and have your best interests at heart. Our firm never represents management companies, and we are not like the go-to person for any one management company. We work with everybody in the Valley. And, we work with everyone in the Valley via our clients. So, of course, we get along with the management companies because we're requesting ledgers and we're asking for photos of things that they may have. But I am not being set work by any management company. My client is the association. Okay, so lawyers retiring. Should this be brought to the attention of the membership if the board's hiring a new attorney? Really, you don't have to tell the membership this, but what you should do is vote on it at an open board meeting and have the minutes reflect it. Paraphrasing the advice of an attorney is never a good idea. I think it's prudent to always get something in writing from the attorney, whether it's an email or a formal opinion letter, so that everybody can see what question was asked and what the answer was. Okay, that's it for our questions today. We had 34 questions, which is amazing. It took us about 42 minutes to get through those questions. Today, we had over 180 viewers at our peak during the seminar today. So that's amazing, really good turnout for our class today. We have one in-person Scottsdale class coming up this month that I want to just make sure that we let you know about. The city of Scottsdale is doing in-person classes right now. And I'm going to be teaching a class on Thursday, September 18th in person between 1 and 3 o'clock. You're, of course, welcome to attend. And it's at Mustang Library. You can find out more information on it on our website. We're going to be talking in depth about the 2025 legislative update and how to effectively work with your community manager and your management company. And again, that's an in-person class that I'll be teaching between 1 and 3 o'clock this Thursday at Scottsdale Mustang Library. We also have another in-person class that we're going to be teaching for Scottsdale on Wednesday, October 8th, between 1 and 3 p.m., again at Mustang Library. And this is going to be practical strategies for aging HOAs and condominiums. Like, where do we go from here? Our association has deferred maintenance. We're looking at a big special assessment. We've got a lot of capital improvement projects we need to do. We're going to be giving advice on aging associations. How do we get back to having things maintained, and how do we turn this boat around, basically? Okay, also, there is going to be our First Fridays. Don't forget about that. Can't believe it's already September of 2020, but our next First Friday is going to be on Friday, October 3rd, between 9 and 10 a.m. First Fridays is your chance to ask one question at no charge, and we answer the questions in rapid fire. You can find out more information on that on our website, where we're going to be sharing information with you now. And then last but not least, we have our October class, which is class number 10 for the Neighborhood Services HOA Academy. We teach that on Zoom and Facebook Live starting at 11 a.m. It's always the third Tuesday of every month. And we're going to be talking about assessments, how to get people to pay assessments, and large capital improvement projects. So that'll be a great virtual class on October 21st. So thanks so much, everybody, for being here today for our class. We look forward to seeing you at future classes, and we appreciate you caring about your association and wanting to make it better. So have a great rest of the week, and see you soon. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.